I call you my
Good afternoon, distinguished colleagues and participants at today's training of the Practical Training Academy. The Practical Training Academy, TPTA, is a not-for-profit company that was set up basically for providing free career development trainings and other initiatives for the benefit of Nigerian lawyers and indeed other Nigerian citizens. And we're delighted today to have the second series since we started delivering these trainings. We are grateful to everyone who's participated in the past, and we are grateful for all those who have subscribed also to our YouTube channel. We have a YouTube channel where we have all our videos stored, and you can access them at any time for free. So we also encourage you to subscribe to our YouTube channel. And at some point during this training, we will also flash the link so that people can click and subscribe. We acknowledge the fact that there's a huge knowledge gap in Nigeria on many areas of practice, and our determination is to help close this gap, and that forms a primary objective of why we set up the Practical Trading Academy. Now, today we are delighted to introduce our first series on intellectual property law, and we're grateful to our facilitators, all of them very accomplished intellectual property law practitioners who have agreed to deliver and facilitate this 4-day training on a totally pro bono basis. We are very grateful to all of them, to Mr. Femi Agaba, to Mrs. Chinaso Wana, Mrs. Nta Epike Mbang, Mr. Christian Anyuku, and Mrs. Ngozi Aderebibe, all very accomplished and distinguished IP practitioners who have given up their time for the benefit of colleagues. We express our gratitude. This afternoon, I'll be introducing two speakers. The first is Mrs. Nta Ebikeng Mbang. She's an intellectual property expert with over 13 years experience in the field. She was called to the bar in 2007. She holds a master's degree from Swansea University, United Kingdom, and is an alumni of the United States of America International Visitors Leadership Program on protection of intellectual property rights. Nta is a Chartered Secretary with the Institute of Chartered Secretaries and Administrators, United Kingdom, and has a certificate in Copyright X from the Beckman Klein Center of Harvard Law School. Nta started her career with the legal department of NIMASA, and then moved on to Kerahi and Associates, and then Alukano Yebode, and later became a partner at TMP before setting up her own law firm, Next. It is my pleasure and honor to welcome Nta to today's training session. Now, the second person who would also be facilitating today's training with Nta is Mr. Christian Anyuku, FIMC CMC KSP. Christian Anyuku serves as the managing partner of Stern & Bland Partners and leads the intellectual property IP and corporate services practice group of the firm. He also had sports sector. He's a distinguished figure in the legal sphere, earning recognition as a 2023, 2024, and 2025 World Leader Nigeria by the World Intellectual Property Review within the trademarks and patents category. Furthermore, he has been acknowledged as a notable practitioner by the managing IP stars and the World Trademark Review during the 2024 and 2025 ranking cycle. He, as well as inclusion in the prestigious AIM 300 IP strategists and so on and so forth. Christian has also been involved in many IP transactions, is actively engaged in the legal communities with numerous national and international groups and associations, including Nigerian Bar Association, Intellectual Property Law Association of Nigeria, International Trademarks Association, MBA SBL IP Committee, and the Anti-Counterfeiting Collaboration, amongst others. Notably, Christian's contributions extend beyond legal practice. He recently assumed a significant role as a member of the Anti-Counterfeiting Committee 2024-2025 term of the International Trademark Association, INTA, appointed the Vice Chair of the IP Committee of the MBA-SBL, chairs the Law Drafting Committee for the Trademark Practice Directions for the Trademark Registry, Commercial Law Department of the Federal Ministry of Industry, Trade and Investment. He's also a member of the IP Working Group of the Presidential Enabling Business Committee. He has been lauded globally, earning recognition as a top IP lawyer by the IPR Gorilla magazine in India and receiving the prestigious Esquire Nigeria Rising Star Award in the under 40 category. Moreover, Christian is a prolific author with several published articles in esteemed local and international journals, further solidifying his reputation as a thought leader in the legal arena. He is a fellow of the Institute of Management Consultants and a chartered management consultant and founder of SCAF, Sir Christian Anyuku Foundation. Christian has worked in some of the most notable law firms in Nigeria and is currently the managing partner of Stern & Blair. It is my privilege this afternoon to introduce Christian Anyuku and Nta Ibikem. I will now hand over to Nta to take things from here. Thank you very much.
Thank you very much, Tobena, for the warm welcome. Good afternoon, everyone. We're just going to go straight into the presentation. So I'm just going to do the introductions, and then Christian is going to take over and take us through the whole presentation. Then afterwards, I will come back for Q&A. Please put your questions in the Q&A box, and after in about 1 hour, 30 minutes, I will come back to come and take the Q&A and read out your questions, so that if you either be Christian answering the questions or I will be answering the questions. But just put your questions into the question box, Q&A section of the presentation. So we're going to get right down to it now. Okay, so just to take us to introduction of intellectual property. What does IP mean? IP simply means, the creations or products of your mind. So intellectual property, it's as simple as that, the creations of your mind, product of anyone's mind. So what the government has done is that people who create, the whole IP system is meant to encourage, and it's meant to encourage innovation, that is the whole reason why the IP system exists. It grants creators exclusive rights to use and commercialize the creation for a certain period. Like I said just now, the objective of IP protection is to encourage innovation and creativity, and it's to reward creators, of people who create, promote economic growth and technological transfer. One of the other objective of IP is to balance the right of creators and the public access to knowledge. You're going to understand all of this, how this works when we talk about patents. So there are different types of intellectual property rights. First of all, you have your trademarks, then you have your patent, then you have copyrights, then you have industrial designs, geographical indications, and trade secrets. Christian is going to go in depth into all of this into all of these categories. But before he goes in depth to it, I will just give a summary of what each one stands for. A trademark is like a signpost to what you have, to your product. It differentiates your product people's products from, from each other. So you're thinking your trademarks, what quickly comes to mind is the Coca-Cola trademark, Pepsi, your close-up, those sort of things are trademarks. If you're talking about your patents are your inventions. So the things that come into mind is your blender, your vacuum cleaner, those sort of things are patents, right? They are inventions. Copyrights, what you think about is your music, your songs, your dramas, your films. Those are the things that are protected by copyrights. Industrial designs, you think about the get-up of the Coca-Cola bottle, that's an industrial design. The get-up of, of any products, that's an industrial design. Geographical indications, you're going to be thinking of something like ofada rice, which is found in a particular area, whiskey, and those sort of things. And if you want to think about what trade secret involved, it's the reason why Coca-Cola is still selling, the reason why Pepsi is still selling it. These are trade secrets. Their combinations are trade secrets. So in a nutshell, this is what we're going to be talking about as a foundation of the framework of the protection of intellectual property rights in Nigeria. So Christian, over to you. Do you want me to continue to share, or you're going to share on your own side?
I'm actually muted. Please continue to share. Just move.
Okay. So just hold on. Do you want me to go to the next page?
Yes, please.
Okay.
All right. So thank you very much for that introduction. You've explained what intellectual property is all about. So we'll move down to the laws and all that. So like Inter mentioned, intellectual property is something you create, and the government gives you some level of protection as an incentive to keep creating, and for other people to also create, because the more we create things, the more we provide solutions to everyday problems and all of that. And the more we provide in source of entertainment and all of that for copyright works and all that. So an incentive for you to create is the government providing some sort of protection, which now gives you an exclusive or exclusivity over your rights to ensure that whatever you've expended in doing the creation, be it a writing, be it an invention, you'll be able to recoup your expenses and all of that. So a brief look at some of the laws for if you're an IP practitioner, or you intend to be one, or you really want to learn IP. So these are the laws you should have: the Copyright Act, the most recent edition, the Trademarks Act, the Patent and Designs Act. So the Copyright Act obviously deals with copyright and the neighboring right and all. Trademarks Act makes provisions for issues around trademarks. We also have a trademarks regulation as well, trademarks regulations. Patent and Designs Act, we have the rules as well. We have the Plant Variety Act, Merchandise Marks Act makes provisions, some provisions touching on issues around trademarks and all. We have Business Facilitation Act, which recently amended some provisions of the Trademarks Act and introduced some, new things. We mentioned that when we are discussing trademarks in full. Then, of course, we have case laws that have impacted on the way we interpret these acts, or the provisions, or the way we handle things in practice. If we have time, we may discuss some of very important case laws. And in the international scene, IP is something that is territorial. We'll talk more on that later. But then there are some international treaties that either that we've, that lay down some basic principles or minimum standards or requirements, or tries to kind of eliminate the multiplicity of filings or registrations that you will do if you really want to protect your IP across several jurisdictions, right? So we have the Berne Convention, mostly for literally, copyright works. So we have in our own copyright act, we, copied, or will I say, made provisions based on some minimum standards provided for in some of these treaties. We have the copyright treaty as well, and all of that. TRIPS agreement is, makes a whole lot of provisions on so many things. But the thing is, most of them, either that we as a nation, Nigeria, will say, we have these dual requirements in our laws that when you sign on any treaty, then you go ahead to domesticate. Because if you sign and do not domesticate, then it won't be enforceable within our jurisdiction. So for many of them, we've signed, we didn't domesticate. There are some, like the Berne Convention I mentioned, that our own law is actually tailored to some of the, minimum standards and all that in the convention, but then the convention itself is not domesticated. Because of that, it won't be. There are case laws that also, because in practice, when we tend to make some kind of arguments and we have supporting rules or principles of law in some of these conventions or treaties, and you try to draw, make reference to them, it's in a way where if you're handling a fundamental right case now, you always try to make reference to African Charter and all that, to solidify your arguments and your grounds. So sometimes practitioners also try to, make references to some of these treaties, but then most times, the courts will tell you that, they are not domesticated and they are not enforceable in our jurisdiction. Next slide. So we'll focus on our own domestic laws in the course of our discussion. All true. All right, so we'll start from copyrights. There are a lot of things under copyright that cannot be exhausted in a day. So we just try to pick some of the basic principles and move on to the next. So to be granted protection or guaranteed protection under Copyright Act, a creative work must meet this requirement of originality and fixation. Originality, in the sense that you've created or you've written something that is an original expression, right? You have an idea which you have expressed in an original way. Ideas are not protected, but the expression of it is what is protected. So you can have a song, you can have a lyrics, you can have a story in your head, and you decide to express that story in a way of dance, or a drama, or write it as a novel or stuff. Anyhow you express it, you get protection of copyright protection. And the law doesn't look at the quality of what you've done. So the focus is not on, okay, whether this song is so sweet or whether the beat is so nice or whether people vibe to it or not, or whether the novel is, I know for us it's usual when we watch movies or read novels and all of that, or we go to the cinema, we see movies, and then we'll come back and start rating, oh, this one is 10 over 10, 1 over 10. When it comes to the law itself, the copyright protection, it doesn't matter. Even if the person wrote, nonsense in quotes, it's still, as long as it has been expressed in that definite medium, it will still be protected. And once it is protected, the person gets the exclusive rights to that. We'll look at what rights a copyright owner has, right? So as long as it's an original work, And of course, it's something, if let's say, like I mentioned, if you have a story, for instance, which has been expressed as a novel, for instance, in a written form, and you have a protection under literary works, tomorrow you can decide to, adapt it into a movie, and that is, another form of copyright, and another form of protection will come up as well. So it's just the way, any original form, the way you decided to express your creative work. And then another key thing is that it must be fixed in a definite medium, in a way that it can be seen or heard all over, not something that is just transient, that just happened once and cannot be recalled or stuff. Those ones cannot be protected. If you just, maybe you just say something or give a narration and that's it, it can't be a protected form of work, because it can't be, there's no way for someone to recall or see it again or listen to it again. But once it has been fixed in a medium where either, just clicking on it, you're able to read or see it, or through the use of a machine or computer or whatever, you're able to access it, then that qualifies, that meets the requirement of fixation, and the eligibility to copyright is complete without any form of registration. So unlike every other form of IP that we'll discuss later on, for copyright, once it's an original work which has been fixed in a definite medium, your protection is complete. You need not do anything further. Oh yeah, of course, under the law, there are other things you can do, but you need not. It's not compulsory that you do that, and that's actually a requirement under the Berne Convention. So the Berne Convention, one of the treaties we mentioned initially, makes that provision that you don't really need someone to take any further step by way of registration and all that for the person to be entitled to copyright. Now you have forms of copyright, copyrightable works that we have under the Act. We have the literary works like the written form, novels, and all of that. We have the musical works. We have artistic works, your drawings and all. We have audiovisual works, the movies and everything, sound recording and broadcast. Just a couple of things I will, mention in some of these. When you come to artistic works, right, the drawings, the paintings, and all of that, there is one exception or proviso under the law, which is that if that artistic work is originally meant to be a model to be mass produced, then it's no longer going to be a copyright, but probably you will find a protection under another form of IP. So if I draw something now, which is nice, it's an artistic work, but if it is now meant to be a model to be mass produced, probably that drawing is now meant to be a label of a product or something like that. It now moves away from copyright into the realm of industrial design. That's basically what the law is saying. And then the law also made mention of you not losing your copyright if the work you did, it's has, if you copied, or if you, let me say, if you infringe on another person's copyright in the production of yours, you would not necessarily lose the copyright of your own, even though you may be open to some infringement actions and all of that. And a practical example would be this. For instance, let's say you adapted somebody's okay, you remember I said something about you expressing your work in a medium, in an original form. That's one of the eligibility requirements. So let's say you have a song, and there is obviously a case like that that's been decided, so I think we can use it as an example. You have a song that you produced, and then some other person comes up the next day to do a compilation of songs, using another beat. Let's say the the case between Saju Dunam and Five Star Music, KC and Emon. You have a gospel song that was produced in a particular way, a particular sound, tone, and everything, and then another person adapts it in a compilation of songs using another beat and all of that. So in that instance, what the law says is that that adaptation that the person has done, that compilation, has its own copyright because it has become like an original work on its own, notwithstanding the fact that he has infringed on somebody else's right. So the person would probably have a right to sue the one who did the adaptation, claim damages and all of that, but that doesn't cancel the copyright of the one who did the adaptation, right? So we look at the rights granted under to a copyright owner. So when you say that you have the copyright over this or that, what's that basically? It gives you the right to exclusive reproduction of the work. Under the previous act, it says it gives you the right to control the reproduction. Under this new act, it says it gives you the right to do or control the doing. So it means you have the exclusive right to reproduce or control the reproduction that every other person is doing. So what that means is if someone wants to, if you have a musical work, for instance, or a novel, for instance, and someone wants to reproduce that in any material form, either having copies or reproduce it in a disc or anything, the person needs your authorization, your license, the way the law will say it, to be able to do that. And in getting that license, it will probably obviously be on your terms. Either the person pays for it, or if you want to give it for free, that's fine. But then that license authorization is needed for the person to escape liability under infringement. It also gives the copyright owner exclusive right to distribution of your work. So if you have a song, for instance, you can distribute it via several channels. You can decide to do YouTube, you can decide to do Spotify, you can decide to do Apple Music, you can even decide to record it in CD plates and send to Alaba and all of that to do the distribution for you, right? To do the distribution for you. So it's these are the copyright owner is the one with the exclusive right to control that. Any other person that will do that will obviously have authorization of the copyright owner to be able to, do that as well. Now we also talk about, performance rights, broadcast, adaptation, a lot of all these. I think I've mentioned adaptation initially, when you have like an original work that you've reduced into writing as a literary work, let's say a novel, and someone wants to adapt it into a movie. Of course, we have so much examples. We have novels that today we've seen that have been adapted into movies and all of that. If you're not the person doing it yourself, then any other person doing it on your behalf or doing it, commercially must get your license or authorization, and obviously it's usually with a fee, it's usually with a fee. We have lots of novels that today have been adapted into movies and they are still doing. And when you look at the agreements, you see that those things don't come cheap. For those who really know their worth, the worth of their original works, you see that it doesn't come cheap for you to sell your rights or license your rights to another person to do an adaptation. You also have the right to claim ownership and all of that. So we have the one we call, apart from the commercial, the economic rights, we have the one we call the authorship, the paternity rights, where you can, where you can, if there's any distortion to your work, for instance, you can speak up against it. A practical example will be something that happened. I think that was in 2018 or 2019. I can't recall the name of the man that did. He said as part of his final year project back then, I think it was University of Benin or so, or OA, I can't remember which exact university, but it's, in the West. As part of his final year project, that he did a sculpture of Wole Soyinka's bust on top of three books, which represents, the drama, the prose, the poetry that, Wole Soyinka is known for. And then it has been there ever since he graduated until recently until that, year when he came back and discovered that the school built a new library and removed the bust, the Wole Soyinka's head from those three books to place on top of the library instead of producing a new one, and thereby distorting the story the man was trying to pass by placing Wole Soyinka's head on top of three books, trying to say this is Wole Soyinka and these are the three things he's basically known for. So in that situation, you can actually you know claim and say that this distortion does not represent the message you are passing at the point of producing this work, and that will be sorted out. Other important things to mention, okay, I've already mentioned the fact that copyright is automatic upon creation and it's not compulsory to register. But then under the law, we have a provision for, previously it was, we started doing this even before the law provided for it. So now it's now in the Copyright Act, which is registration with NCC to give you proof of ownership and date. One thing you will notice is sometimes if you've read through some copyright cases, both locally and internationally, you'll find out that there are sometimes this issue of date and trying to claim who produced first. Because the truth of the matter is, as you are here, trying to generate, or you've generated an idea in your head, someone else somewhere else actually probably has the same idea or is also coming up with the same idea. So imagine a situation where, you have your idea and you have expressed it in a particular form, and then you've, distributed, and then someone else expressed is almost the same idea or the same idea in another form or the same form like you, and distributed somewhere else, and then both of you, it seems somebody's copying somebody. It now boils down to the question of who produced first. So that's why sometimes in some of the cases you see the issue of date will, be a problem. I produce first, I produce first. In the absence of a registration is not required. So in the absence of registration, then who is now the real owner? So when that issue comes, that's why NCC started. Initially, they called it notification with NCC. Now it will be called a registration. So if you have a copyright work now, it's automatic. So don't confuse it. Your protection is, your right is automatic upon creation. So that's fine. But then if you want to take a step further by having a certificate of registration or having a proof that you actually own this, you go to NCC to register. So it is very, very advisable to do a registration, because tomorrow, even if you are trying to license your work to a third party or anything, how do you show exactly that this belongs to you, right? So that's where the certificates usually come on, into play. So you register with copyright, and the registration process is actually pretty fast and very quick. Register, you supply the details that are needed, and you issue a certificate. I recall that there is a case, a judgment of the Federal High Court. I was trying to look for it initially. Federal High Court cases are mostly not reported, so it's not easy to find when you are looking for it. But I recall sometime 2020, 2019, 2020. I read this case where someone, tried to prove ownership of a copyright work with the NCC certificate, and then another person who has a prior ownership right. Someone was trying to say, let's say A was saying that B copied this work from him. And B said, no, I couldn't have copied it from you, A, because I have a certificate from NCC that shows I registered this work, I'm the owner of it, and all of that. But in that case, A was able to show superior ownership by showing timestamps and everything to show that he actually created that work prior to the date of registration by B. And in that case, the court said that the certificate you have, the registration certificate you have with NCC is not a conclusive proof of ownership, because the act says your copyright takes effect upon meeting those two requirements of originality and fixation. So even though A did not go the step further by registering, but he has circumstantial evidence to prove that he created this work before B, his right was deemed superior, and court recognized his right and cancel the certificate given to B. So just note some of these. So it doesn't mean that once you have the certificate that in this, where some people will just rush to copy some things. For those of us in IP, we see a lot of copying here and there. That people will go to copy something another person has developed or created, and then you rush to go and register it, and thinking that that gives you a right over the real owner. It won't work that way. So period of protection. So the different works has this different period of life of the author. For the literary, artistic, and lots of them for last for the entire life of the author and 70 years after. So that's why you see people like Fela and co, those musicians or performers and all of that may be late, but then they still have their rights are still protected, because copyright is, it's a statutory right. You can, it's a property, just like the way we call it intellectual property. So the same way people will their physical properties and all in their will, before they die. That's the same way you can actually will your intellectual property. So you see things like estate of so going to court against an infringer. Because some persons will think, oh, because this musician is dead, I can now go ahead to copy his work or go and remix his song and all of that. No, the IP right is still on. The estate or whoever it is will to the next of kin or anybody can still take up an action against any infringer. And every royalty, if you're using the song, just recently, I think it was just yesterday or so, I saw in the news that what's the name? According to Forbes or something, that Michael Jackson is the top for 2025 one of late artists that has the highest royalties paid for within the year. So that shows you that even if the person is dead, the royalty, the money, the license fees are still coming in, and whoever is now in charge will keep taking the money and administering it as necessary. And then for the other rights, you have the 50 years. So the effect of the duration is once the duration has elapsed, has expired, then the work moves into what we call, and that is when everybody can now use it freely. So January 1 of every year, you will probably, if you listen well, you can just browse it. January 1, you will see something like it's actually January 1 is actually called the World Public Domain Name, something like that. So every January 1, you hear of copyright works that have entered into public domain for that year. I think last year was the initial Mickey Mouse design or something. So that's how. So some years you hear, oh, that this novel or this work by Shakespeare or this person or that person has now officially entered the public domain. So you can now freely use it or adapt it without, you know, what's the word, without authorization or license from the owner. And previously, under the former act, under the previous act, the authorship right that we mentioned that says that you have to mention who the creator is, but it's a perpetual right. What that means is if even if the copyright has expired at the end of 70 years after the life of the person, you use the person's work, you will still have to mention, that this is that so is actually the creator or whoever is the copyright owner, something like that. So the only thing is that you don't need to get the person or the estate of the person to give you authorization or license. But the new act says that that right, claim authorship and every other all those paternity rights are now restricted to the same duration as the copyright itself. So that's a change on that law. So we'll move to the next one. I think it's trademarks. Yeah. So trademarks is can call it a mark used or so let me place this caveat. I will be using the term trademarks. I know for some circumstances, the actual term will probably be service marks, but we'll have what we call trademarks, we'll have service marks, depending on what is being used for what, trademarks is what I will use all through. So trademark is a mark used or proposed to be used in relation of goods or services for the purpose of indicating a connection between the goods and services. Previously, that is why I mentioned Business Facilitation Act as one of the laws we will discuss in the course of the discussion. And that is because this inclusion of services was introduced statutorily under the Business Facilitation Act. I know that we used to do it. I think it was a memo, a circular or a memo issued in 2007 by the then minister that said services are accepted. If you pick a copy of the Trademarks Act or the Trademarks Regulations, what you actually see is under the schedule where they listed the classes of goods for which you can register your trademark. But trademarks are registered in classes. You cannot just come and say you want to register ABC trademark. You must register it in a class. Back then, we had only 34 classes, 1 to 34. And that 1 to 34 were for actual goods, physical goods. You see things like chemicals, you see things like soaps, detergents, this and that, medications, for actual goods, products and services, for products. But when that circular was introduced in 2007, it allowed for registration of trademarks in classes for services, which is now from class 35 to 45. 35 we talk about business management, officers, functions, and all of that. 36 financial services like banks and all of that. Telecommunications, hospitality, down to 45 that provides for legal services. So as a lawyer or a law firm, you can actually register your service mark, your brand, logo you use, and all of that in class 45, for instance. It becomes your registered mark as well, right? So that's what's it called? That allowance to register that from 35 to 45 is not in the Trademarks Act. You won't see it even in the regulation till date. But the Business Facilitation Act amended the Trademarks Act by allowing services. So when you read the Trademarks Act, what you'll be seeing everywhere, even in definition, is goods, goods, goods. There's nowhere you will see services. But now, services are now statutorily provided for. So the classes 35 to 45 that we have been doing is now legitimate. They are now statutorily provided for. Right. and to be guaranteed protection. So there are things we also look at in the next slide, how to even choose a trademark and all of that. But one thing you will know is one key thing that is associated with trademark is the issue of distinctiveness. You cannot have an exclusive right to a trademark if it's not considered distinctive. Even if you register it and it's not distinctive, it won't serve the purpose for being a trademark. And I will give you an instance. If you have a trademark that is distinctive, the Coca-Colas, the Microsoft, and all of that, that once you mention this name, or once you see that logo, that name on a product, you already know where the product is coming from. Once you see all of that, once you see that, right, it, it means that the trademark has served this purpose of being a source indicator. And where this thing works is, for instance, let's say you travel abroad, you are in Nigeria, you are used to our pet drinks, the beverages and all. And then you travel abroad, for instance, and let's say you travel to China. And this actually happened to me, especially when I went to China and Japan. You're looking at a lot of drinks, you're seeing names written in different forms and everything in Chinese language and all of that. Even the ones written in English, but you can't, you don't know the product and all. Then, but you really need something to drink. But you can't trust, you don't know all those things. You don't know if it's alcoholic drinks or beer or anything. And then on that shelf, you just see one can written Coca-Cola. That gives you, kind of comfort to say, oh, I know this one. At least I know this particular product, and then you pick it and pay for it. So that means that that Coca-Cola written on the bottle has served its purpose of being a source indicator. Because you've seen the name, you have now, your mind has calmed down that, oh, at least I know this product, I know the source of this product, I can take this one. I don't know these other ones, but I can take this one because I know this one. So that's actually the essence of trademark, to serve as source indicator. If you mention Zenith, with the red, you just see the Zenith with the red everything on the top of a building, your mind will tell you this is Zenith Bank. If that's the function of a trademark. I know in reality, that's why if I'm advising a client, for instance, when we move to the kind of trademarks, I will explain that in full. If I'm advising a client when choosing a mark, I will always tell them stay away from names that are very will I say controversial, or that are very common, that can't be, that can have that effect, that criteria of distinctiveness. A trademark has to be distinctive because that's when it can really, really perform the function of being a source indicator for you. Other requirements, it must not mislead or deceive consumers, it must not violate public order of morality. There are some years back, there's this trademark that was filed for and it was refused, and it's a trademark for fat bastard, and it was refused. I know in some jurisdictions it was accepted, but all these IP rights and all, they are all territorial. So something that is accepted in the US must not necessarily be accepted in Nigeria. So it must not violate public order or morality. There are some words that when you want to register, it will be refused because the examiner will view it as something that violates public order or morality. It should not be identical or confusingly similar to an existing trademark. Very key. We'll discuss stages or how trademarks are filed. That's where you see why this is important. It must not contain scandalous designs or deceptive designs. It must not contain restricted words. There are some words you can use. The same way in registering a company at CAC, there are some words you can use. Same thing for trademarks. Now, you look at the cadres. So this plays a role when you're trying to choose a trademark. At the apex is the fanciful trademark, right? Fanciful trademarks are trademarks that before you created them, there was nothing, that word was not in existence. You are the one that invented this word. So if you're able to market your product or service with that mark and it becomes popular, it will, be fixed. Like everybody will know you with that. And whenever that name is mentioned, people's mind will just go to you. So you have things like Monster Indomie. Indomie is very popular. In fact, people now go ahead to refer to other noodles as Indomie. Some persons don't even know. I've engaged in this argument a lot. Even when I was still in school in the university, I know I engaged in this same argument with a couple of classmates a lot. That Indomie is not noodles. Like Indomie is not the is another name for noodles. That Indomie is a brand name. A lot of people take Indomie to mean noodles, and then we now ask them, okay, so what are the types of Indomie that in quote that you know? They will not tell you there is super pack, there is chicken this, there is so Indomie is a brand of noodles. Same way you have Chiki, same way you have what are the other ones? Dangote and the rest of them noodles, right? So these are fanciful trademarks. Before the company generated or came up with that name, it was not in existence. You go to the dictionary, you won't see it. It's a word that they generated um, themselves and made it popular. So it's at the apex. And it has some implications. So if you go to the Trademarks Act, for instance, I know it's not part of the topic because if we go into everything, then we won't finish in 2 days. If you go under the Act, there's a place where the Act makes provision for defensive registration of trademarks. And you'll find out that the Act limited it to fanciful marks to tell you how, very important or at the apex this set of trademarks are. So if you have a trademark, let's say like Indomie that you've generated and it has become so popular that even if remember I said trademarks are registered in classes, the class of goods or services that you use them for. So even if let's say for Indomie now, you're using it for noodles and you've registered it in maybe 29, 30, 31, all those classes that have to do with food. But you know that if somebody registers Indomie in, let's say, class 5 for medication or class 39 or so that has to do with hospitality, that it can cause a confusion. People would probably think the product or service the person is doing is related to the Indomie company. Then the law grants Indomie the right to defensively register their trademark in all the classes. So they can just register it from class 1 to 45 and they don't need to use it. Even though the law says if you register a trademark, you must use it because if you don't use it, somebody can come and say, maybe after 5 years or something, somebody can file for non-use and then the trademark will be removed from the register. That works for normal trademark registration. But if it's a mark that has been defensively registered, that you don't need to use it because you defensively registered it to block every other class to make sure that nobody else registers your trademark in any other class be able to use it. So that's one of the benefits of having a fanciful trademark. Then you have the arbitrary trademarks. This one are very, very strong trademarks as well. So they are common words. If you look at the dictionary, you will see their meaning and all that. But the use, how they are used as a trademark or service mark is totally different from the original meaning of that word. So, like you can see from this screen, you have apple. Apple is a fruit. We eat apple. In fact, their logo is an apple, a bite. But then it's being used for computers, phones, which is totally unrelated to the meaning of apple in the dictionary. So that's an arbitrary trademark. You have dove, a bed for soap, deodorant, and the rest. You have Amazon, all and all that. There are so many examples like that. So the law also considers arbitrary trademarks as very strong kind of trademarks as well, right? Then you have the suggestive trademark, which is also strong. Suggestive in the sense that it is not descriptive, may not be fanciful, but when you mention that trademark, even without somebody like, let's assume you've not heard of that before, but when it is mentioned, your mind can relate, can try to fix, where that trademark is, the kind of goods or services it's being used for. So you look at the examples that we have. You mentioned something like Netflix. It sounds like something, internet, net. You know, your mind can easily go to. It suggests to you that this is something that has to do with internet streaming, right? You mentioned Walmart. The presence of mart will probably take your mind to the fact that this has to do with a shopping mall, a shopping center, that kind of stuff. So these three sets, suggestive, arbitrary, fanciful, they are considered very strong trademarks. And if you ever have to advise clients, it's best to have a trademark that fits into any of these three. Now, the last two, descriptive. Sometimes descriptive trademarks may be registered. In the law, section 9, say it is not, but depending on how it is placed or the combination of what and what you have there, it may pass examination, but it's not recommended. Do you know why? Even if you succeed in registering it tomorrow, B succeed in registering it, C succeed in registering something similar, and then you go to court and say, I have this trademark, and B is using something similar, C is using something similar, that they should be stopped. What they can simply, in their defense, say, all of us, this is something we have been coexisting, let's simply continue to coexist, or that a part of your trademark or the trademark that you are trying to claim ownership over is actually a very common word that is used in our business, in our line of business, so you can't stop anybody from using it. And at the end of the day, the tribunal, trademark tribunal, or the federal high or the court will just say, you know what, you're actually using a word that everybody in this line of business is meant to be using. So that your registration is nullified. Everybody feel free, use it. Or they say, you use it, we use it, everybody use it, all of you can coexist. So that's why it's not, advisable to use the script. So if you know that a word or a term, a logo or something is something general that people in a particular line of business would normally use, try to avoid using it as a trademark, because one day it may either become generic, or you see that a lot of persons are using the same thing that can't really claim exclusive rights or ownership, or even you won't be able to stop them. So you see an example that we use, if you have, let's say, an eye clinic or something, and then you now want to register a trademark or a service mark for it, and then you are now including vision center. How do you think that tomorrow you will be able to stop another person from also using vision center for, the eye clinic and all of that? Then at the least is the generic mark. These ones are not acceptable in the first place. But the flip side of it is that there are some marks that are either fanciful, arbitrary, or whatever at the beginning that will later now turn to become generic. We call it genericide. It's just like saying that a trademark committed suicide, it killed itself. And that happens where, if you go on Wikipedia, for instance, and you Google trademark Nigerian brands or trademarks that are prone to genericide, you'll see names like Maggi, Indomie, what's this one? This detergent, Omo, and the rest of them. And how does that happen? It usually happens where your product is the first to hit the market. You debut your product in a particular industry or field. And then you become so popular that people now refer to the product with your brand name instead of the trademark. So a perfect example is Indomie. They started with all this noodles thing, and everybody, we all became became so popular with everybody, it became, it became a household name, right? And then the thing is that some persons now left the aspect of knowing that this is noodles to start calling it Indomie. And then the effect is that when other noodles start coming on board, we continue referring to all of them as Indomie. So it's not a funny thing where it's not a new thing where you go to a roadside store, for instance, and you say, because if it's in a supermarket, you can pick what you want and then go to the counter. But if it's on this roadside store, you come and say, I need Indomie. And then you hear something like, which one? You answer, give me chicky chicky. And the person will just stretch and I give you chicky chicky. In their head, they're giving you chicky chicky Indomie. Or you now come and say, I need Omo. Person say, which one? Omo is a brand of its own. You understand? So that's the process we call genericide, where the trademark has now gone from being very fanciful or very distinctive to now becoming generic. There are so many, if you just go online, just about trademarks that have become generic. There are lots of them. Escalator, all of us say escalator these days. You don't even know that escalator once used to be a trademark of a brand. Aspirin, Bandage, what are their names? A lot of them. And there are some marks that are almost at the edge of big. Like in the US, for instance, you hear, instead of them saying photocopy, what you usually hear is Xerox this thing. In movies, when you go there, you see in many offices, it happens a lot. Instead of saying photocopy this for me, you hear Xerox this thing for me. Even here in Nigeria, we make that mistake of saying Google this. I've been very careful to use browse, not Google, because a lot of us, make that mistake of, oh, let me Google it. Google is trademark of a brand. It doesn't mean the act of searching for something on the internet or something or something. So you say, let me Google it or that kind of thing, it's, trying to put Google in the area of being generic as well. So for that side, is generic side, the issue of generic and generic side is a whole topic on its own because there are things brands are encouraged to do to maintain their what's it called distinctiveness. So these are some examples of trademarks. We have this slide because we want to show you that trademarks can come in different forms. It can be word marks, can be logo, can be composite marks, that's both word logo. It can be even the non-traditional marks, right? Even though in Nigeria we don't, our database has not upgraded to accept some because there are some jurisdictions that smell, scent of perfumes, all those things, can be registered. But the way our manual system is here, even the online system, we've not gotten to that stage yet. But there are also very interesting ones like the red soul mark. So under the Business Facilitation Act, so this is also a reason why we're going back to Business Facilitation Act. The act expanded the meaning of trademarks to include so many other things like shape of products, combination of colors. There are colors that are actually trademarks, right? It can be one or combination of two. I have a client that they are very popular. Their main trademark is combination of two colors. No name, no logo, no just two colors in a rectangular format. We have so many of them like that. So these are all types of trademarks and they are all acceptable. Then we now go to the registration process. We try to rush it because it can be very complicated at some point. So the first thing that is always advisable to do is to do a prior search. A lot of people jump this stage. Don't blame anybody who do that, but it's advisable to at least do a prior search to even know. I think recently someone was asking me that he or she wants to register 30 December. And I said, okay. In my mind, two other persons have asked me the same thing that they want to register 30 December. And I said, if three persons have asked me that they want to register 30 December, who knows how many persons that must have registered it even before now? And I said, okay, let me just even do a prior search. And we did a prior search, a simple prior search, and just in, I think, 1 or 2 classes already, we saw more than 5 30 Decembers already registered. So in that instance, if you want to register a trademark and you do a prior search and then you're seeing that there are already existing trademarks or similar ones, what that tells you is that even if the examiner makes the mistake of accepting your trademark, which happens sometimes, and because our system at the registry trademark registry is largely manual, so it's possible, they will miss out on a prior mark and accept yours. But if there is a prior mark, then wait for opposition. There is an opposition I'm doing now that as we filed an opposition against that, 2 more persons filed an opposition. So like the person that filed the application is facing opposition from 3 different entities. It happens. So that's why it's good to, do a prior search. If the mark is free, then you go ahead to register. There is even something under the act that says you can even ask the registrar for what we call preliminary advice, right? You can apply to the registrar of trademarks and say, I want to register this trademark. What do you think? Especially in terms of distinctiveness. Because when we go to examination, you will see the things that the examiner will look at. So all those things are the things you can do prior to filing for the registration. Then at the stage of filing, previously we used to have manual process, online process. I think the manual process is still there, but we largely file online. So you file your application. Upon filing, you put all the details, you get an acknowledgement form. That serves as, an evidence that you have filed this trademark. Then it moves to examination. Now, for the examination part, the examiner looks at first that prior search aspect. They will look at trademarks that have been filed in that same class, the ones that are similar to the one you have filed. If there is any, they will flag it. If there is none, they will move it to the examiner. Even if there is any, they will still move it to the examiner. The examiner is the one that decides. So when everything comes to the table of the examiner with the material, maybe prior, what's it called, the prior trademarks in that class or anything, the examiner will now check, are these trademarks really, really similar? If it's similar, it can be a ground for refusal. They will refuse your application. If it is not, they will leave it, right? Or they can simply, if there was no prior mark that was cited, then the examiner can simply accept your application. But even if there is no prior mark cited, the examiner may still refuse the application if you remember those things that we mentioned. If it is contrary to morality, public order, if it contains any of those restricted or all those things, it can still be refused on those grounds. So that's what happens at examination. Examination is checking if there are similar marks and checking if it is in line with the provisions of the law. So assuming everything is fine, an acceptance letter will be issued to you. You will hold it as proof that your trademark has been accepted. Then you will now wait for when the trademark will be published in a journal. Our journals are still done physically in hard copy. I even have one in front of me here, very large volumes. They publish trademarks in journals. Some jurisdictions they do soft copy PDF, which makes it easy. When a trademark is published in journal, you wait for 2 months for any potential party, anybody to oppose it. So brand owners will usually go through the journal to see if somebody is trying to file a trademark that is similar to theirs or stuff like that. If after 2 months nobody files an opposition against your trademark, then you can go ahead to make your payment for certificate. In between all these things, there are some internal things that they do at the registry, but those ones are not for our discussion. But what you know is that if there is no opposition after the 2 months deadline, and that 2 months deadline has no extension, it's 2 months and it's 2 months, no extension. You can proceed to pay for your registration certificate, right? Now, at that step 3, examination, if your trademark was refused instead of being accepted, you have options. You file an appeal, you ask for a hearing to argue why it should be accepted. If the registrar at the end of the day still says, despite all this your representation and your argument and everything, I will still refuse it, then you now go to the Federal High Court. An instance where a trademark can be accepted after being refused is, for instance, if you have a trademark called ABC, and the company that filed it is known as XYZ, but that company later changed its name to FSB and filed another trademark similar to that ABC. And then the registrar looks at it and say, this ABC trademark has been filed by XYZ before, so why is FSB filing it now? And he refuses the trademark. And then you come during that hearing or in your appeal and you say, oh, that FSB, that first one that was filed by XYZ company is that you refuse to, is please, it's the same company, it's just that they have changed their name. This is the proof that they have changed their name. So it's the same company that is registering the same trademark or this similar trademark. When the registrar looks at it, oh, it's actually true, it's the same company, they just changed their name. You can now go back and accept it, and then your trademark will proceed. So when your trademark is registered, it lasts for 7 years from the date of filing. So the date of registration is considered to be the date of filing. If you bring your trademark certificate, you will see 2 dates. It's usually confusing to some. Date of registration is deemed to be the date of application. So if you filed it 2 years ago, but it was registered 2 years after, it starts counting from that 2 years before that you filed it, right? So note this, please. Date of registration that you will see on the certificate, there's a date that's written sealing date. That one is just the date they sealed it and signed it at the trademark registry, but that's not the date it was the registration takes effect. So 7 years takes effect from the date of filing, after which you renew every 14 years till infinity. Till date, you can still see trademarks that were filed in 1914 and all of that are still in existence. That's for trademarks. Then we'll go to patents. So patents are for inventions, simply put, right? Inventions that have where you're trying to create solutions for humanity. You are inventing a chair, it can be a foldable chair, it can be a foldable table, it can be a moving fridge, anything, right? The requirements are there. One is that the invention must be novel. So when it comes to patents, that requirement of novelty is stricter. We talked about originality in copyright, which is a bit, easy. But that in patents actually very strict, because patent rules or laws says that your invention that you want to protect should be something that has not been seen anywhere. And anywhere in this case actually means anywhere in the world. So it has to be something that is new, or something that is an improvement on something, on an existing invention. So it can be something that is entirely new, that never existed before. You just came up with an idea on how to make people to teleport, or how to, fly just a tire from Lagos to Ibadan, something that's never been in existence, or something that is in existence, but you have now added an improvement that is not obvious. So let's say initially back in the days, we only have seats that you just place on the 4 legs and you sit down. It can be moved, it can be rolled or anything. And then someone now comes up with an ingenious idea that instead of having just these 4 legs, that you just place this seat, and why not put it from a tire or something that will make it to be easy to be rolled round and round. So that is an improvement on an existing invention. So it becomes an invention of its own, right? It has to be industrially applicable, which means it has to be easily multiplied when we use the format you have provided, and it can be used in any industry, even in agriculture. So when you're filing a patent, for instance, we'll still look at the things you submit. You come under one of the document where we call the description. you have to describe your patent in a way that when I remember the patent you're filing is not something everybody knows. You understand? It's something that you invented. And at that point that you want to file it, nobody has seen it, nobody knows about it, just you. Because you actually need to file for your patent before you disclose your invention. So you have to describe that patent in a way that if somebody skilled in that act, in that industry, takes the steps that you have described, the person will come to the exact same conclusion that you did. So, for instance, if you say that your invention, let's say back in the days, we only had telephones, the ones that we have, they connect to the socket and all. And then somebody once now came up with the mobile phone, and then the person now under the description described it as I will pick one metal, plug it into metal B. I will insert chip A, plug into chip B, and do this and do that, and then that is how I will come up with this phone. If I take that document and I do exactly what that person has said, I should be able to come up with the same result the person did. That is a requirement. If I do it and I don't come up with the same result, it means the person has not described the invention in a way that should be accepted for registration. While it is important is this, if you file your patent and it's accepted and registered, the law gives you 20 years of exclusive right over the exploitation of that patent. So which means within that 20 years, no one else is allowed to use your patent. No one else is allowed to exploit your patent, without your authorization. There are a few exceptions, compulsory license and all. We may not go into all that, but that is general rule. No one else is allowed. So in exchange for that exclusive right that the government is giving to you, if you look at the patent certificate, it's actually written in the name of the president. His name, you see Bola Ahmed Tinubu is giving you the certificate. So in exchange for that, you are disclosing that invention such that immediately your patent expires in 20 years, it enters public domain, every other person can now use it, multiply it, and provide that same solution to the whole community, and so that everybody will be happy. So that's the essence of how patents work. And there are some few things you will note. Like I mentioned, you don't disclose your patent before registration. It's not a wise thing. Yeah, I know it's not even nice to say, but I know in Nigeria, they may not be too strict. They may not be too strict to check whether it has been disclosed or not. But these are things that can be, if you have an opponent or a competitor that is very strict, these are the grounds that the person can use to challenge your patent afterwards. So the best thing is don't disclose before protection. Even if you have like people that like some of these startups that come up with innovative things and then they are already going to pitch and all those stuff. Very best thing for you to do is first of all register it before you go ahead to disclose. An exception to disclosure will be if you disclosed it in an official exhibition. Sometimes government, I know the Ministry of Science and Innovation or something, sometimes they organize these exhibitions, where people will come up and exhibit what they've come up. I know I watched one I can't remember who organized, but I know it was government, where people showed how they came up with all these small tractors that we can run using water, or these people that build planes and aeroplanes and small helicopters that can just use battery, all those kind of things, or generators that can just use battery or charcoal, or those are inventions that are patentable, right? If you disclose it in an official exhibition, such as the one organized by the government, the law allows you to still file your patent within 6 months, and that disclosure you did won't be allowed to nullify the patent. So it won't defeat the requirements of don't disclose prior to filing. So that's just basically what it's saying. But if it is obviously not an official exhibition or you didn't even like just went ahead to disclose your patent anyhow, and then you come back for filing, that may be a ground to notify it if the patent registrar didn't flag it already. So when you file, the process is quite simple. When you file, you have a number of documents you are meant to provide. You have to provide specification of the invention, including the claim. The claims is very important because that's actually what you're protecting. So after all the bunch of documents and everything you have written, it boils down to the claims. If you go to court tomorrow, if you have a case, someone is challenging your patent and everything, it boils down to the claims because that's where you're actually saying, especially where it's an improvement on something that is existing. Because it's in the claims that you're saying, this is the exact thing I have come up with. I am claiming this special feature, that special feature, this one, that one, that one. So that's the claims will be there. Drawings will be there. Obviously, you have to draw all the necessary things, put not just to draw the final, you have to like in form of sketch and all that, drawings and plans and everything. A power of attorney is needed for the agent that is filing for you and all of that, payment of prescribed fee, and then you fill the form. That's the things you need to supply. Once you have put all those things on the online platform, an acknowledgement form will be issued to you as proof that you have filed the patent. Then it goes through examination, just like trademarks. During examination, the officer looks at whether what you are filing for is so under our law actually, they are not allowed to do substantive examination. Our examination is only as to form. So the two types for countries where they do substantive examination is that, remember I mentioned your description, you should be explain it in full disclosure. That's the word. You have to fully disclose. You explain it in such a way that if another person follows the step, the person will come to the same conclusion. That's one of the things they do in substantive examination. So in substantive examination, you cannot just come and say, I did A, B, C, and came up with D. They will do that A, B, C, D to come up with it. And if they do it and they don't come up with it, it won't be accepted. Right? So, but for us, under our Patent Act, all that is required is formality check. Have you uploaded your power of attorney? Did you upload your drawings? Did you put your claims? Did you provide all the details necessary, the email address, the inventors? Once all those things are complete, they accept it. Even though in reality, the patent registry sometimes tend to look at some subject matter. They try to say, oh, that this patent you have filed is not really a patent. Why not consider business method, utility model, this and that? But for the purpose of the law says the examination is only as to form. If everything is cool, then acceptance letter will be issued to you, after which they will go ahead to print your certificate. The law says after certificate is issued, it should be gazetted. But in reality, of course, because of maybe materials and all of that, feasibility and all of that, we don't go that stage. But so once you have a certificate, that's fine. Just go, it lasts for 20 years, but you have to be paying your renewal fees every year. It's yearly. Next slide, please. Now we move to the next IP right, which is industrial design. Industrial design, I don't know, in practice, it tends to be kind of the least talked about or the least I don't know why. And it's even the Business Facilitation Act now made it now spoil industrial design the more by saying that those things that ordinarily should be or that can come under industrial design are also eligible to be protected as trademarks. So when the Business Facilitation Act is saying that you can register product package and all of that as trademarks, it means people will now run away from industrial design, and it's for a reason. Trademarks last in perpetuity as long as you're renewing every 14 years. But industrial design lasts only 15 years, and that's the end of it. So when you have those two options, which one do you choose? You choose the one that will last forever, and people do it. I mentioned the example of Mickey Mouse some minutes ago. The copyright may have elapsed, but guess what? The trademark is still there. So in everything you do, you will still need their authorization to use it. So industrial design normally should protect the aesthetic value of a product. The aesthetic value of, so not if the design that you're talking about has to do with the functionality of that product, then it can be called an industrial design. So if you have a laptop, the screen, the keyboard, and then of course the keyboard must be on this side so that you can type. You can't call that shape an industrial design because it's a functionality of the whole setup. If you have a bottle that is just like straight down, you can't call it an industrial design because without the bottle, the water can't hold inside this thing, this plastic, right? It only becomes an industrial design where outside of this bottle that is holding the water, you have gone ahead to make some beautiful markings, some very unique markings and engravings and designs on the bottle, such that even without those designs, the bottle will still hold the water. But the designs are just there to make it to look more beautiful. That's the essence of industrial design. So it has to be something that is new, a design that is new. It's not something that is already. That's why most times you see, of course, there are lots of bottled waters, and then each of them, they are trying to do something different with their bottle. This one will be in this shape, the other one will be in this shape, the other one will be like this. They are all trying to create something new by redesigning the shape of their bottle and all that. Coca-Cola bottle, you see how different it is from other ones. So these are industrial designs. When you try to create something new and very aesthetic, something that is pleasing to the eye, you have your you have your protection, and it lasts for the first 5 years, then renewable for further 2 more 5 years, which is 15 years in all, and nothing more. So I think the next one, okay, the process very similar to patent. You file, yeah, there was something no, we can go back to the side. Yeah, something, because patent and industrial design are in the same act. So apart from the few provisions where they are talking about each of them individually, most of the provisions are for both. Now I have something that we call statutory inventor and true inventor. I think someone asked me that thing very recently, so let me just mention it as well. In a patent application, you will see where they will ask you who is the applicant. That is what we call the statutory creator, the person that is filing it. And it's in that person's name that the patent certificate or industrial design certificate will be issued. But then again, down the line, in the same form, you will also see a place where you are asked who are the true inventors. Because this thing comes with, these are like very ingenious, something someone has come up with. The law sees it that it's very important to, even if the person is not the one being issued the certificate, but we should recognize the efforts of this person, right? So you have true inventors, the real people that invented the stuff, the whatever you want to register, and then the statutory inventor, the person that is now registering, the person that the registration certificate will come in his name. You may have some arrangements on how to settle all that if the person is not an employee and all of that. But at least for the purposes of the filing, you will recognize the true inventor in that form and also file it in the name of whoever is the statutory, that's the applicant for the purposes of the registration. So for designs, you also file your specimen of the design, indication of the product, a lot of it's just all those things, the forms, fill everything, power of attorney, upload, everything is cool, you file, it's examined, if it's fine, it is registered, if it's not, it will be queried and all of that. We've talked about the duration of 6 years and all those things, they have grace period. But in effect, because we don't pay penalties in Nigeria for late filing of renewals, people tend to miss um, their renewal period and then pay later. Trade secret. So this is not a statutory IP right, kind of, but it's also very powerful. Powerful in the sense that if you keep it secret how it should be, it will last forever and it will keep your business going. So during the introductory session, Nta mentioned that Coca-Cola is still Coca-Cola today because of its trade secret, and that is just the truth. You just go online, browse how Coca-Cola's trade secret is handled. Very detailed, down to when I read about it the very first time, down to the fact that the two persons that will hold the secret at each point in time would enter the same plane in case of anything. Understand? So you have to, for something to be called trade secret, there has to be an information that is very valuable, that gives you a competitive edge over your competitors. And it must be confidential in the sense that it is not an information that everybody, even your staff members, not even talk of outsiders, even the entire staff members of the team, just like the Coca-Cola formula, even the top management itself, they don't even know it. You understand? That's why it's a secret. It's something that gives you a competitive advantage. Somebody was saying the other day, that like some of this franchise, this food, like KFC, what are their names? Chicken Republic and all of that. There are some of them that when you go to any of their branches, what you eat tastes the same. And you now be wondering how, right? It's because their recipe, for instance, is a trade secret. You may be wondering how are they able to keep it a secret if maybe the chef in branch A is told what it is, chef in branch B is told what it is in C and all of that. And I can tell you because at least I know one that I've worked with, so I know how they do theirs. Now, you as a chef in branch A, you will never know how they came up with that recipe. All you know is that every morning, probably depending on how they handle their distribution, they will supply all the branches the packs of the rest, like call it an ingredients or something already made in a particular way. So all you need to do, they will tell you maybe for one pack of this, you will need, let's say 5 kg rice. So, and this is the format you will do it. So you will know how to prepare it, but you don't know how that particular recipe was prepared. That one is the one they keep as their trade secret. It will probably be maybe one or two or three, four persons in the top level that will have access to that preparation formula for the recipe. So that's how to keep a trade secret. One is that you must have taken reason. You can't just come and say, that this person is spreading my trade secret when you yourself you have not taken reasonable steps to keep it a secret. And how do you take reasonable steps to keep it a secret? I'm sure some of you must have encountered situations where probably you are working in an organization and then you take your flash drive insert in your office laptop, you want to copy something and you find out that you can't copy it. That is reasonable step to keep it a secret. You see your employment letter when they will include a clause on confidential information that, in the course of this, blah, 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 you must not That is taking steps to keep it a secret. Or like I mentioned in patents, you are maybe a startup or you invented something and then you want to meet a potential what they call it investor. And then you first of all you come, you say, please let's sign this non-disclosure agreement first before I will tell you what I want to tell you, which will make sure that this thing I'm about to tell you is just between us and you're not going to say it to a third party. That is taking reasonable steps to keep it a secret. So there must be reasonable. Another way is maybe it's even as common as you have a restaurant, you have a recipe, and it's only you, the madam, the proprietor, the boss, and one or two chefs. In the midst of your 70 staff strength, only three persons know about that. That is taking reasonable steps to keep it a secret. Understand? Because if a trade secret matter goes to court, you have to prove that you have taken reasonable steps to keep that information a secret. It's one of the things you have to show. Because if you can't show that you have, then it's as good as saying that the information is free for all. Understand? So the next one is that that information must be commercially valuable, something that is very valuable. It's not, just anyhow. It must be like at the core of your business. It must be at the core of that thing that is making you have that competitive advantage over your competitors. It must be at the core of that thing that is making you to generate revenue. And then it must not be readily ascertainable. It's not something that if somebody by just mere looking at it, like if I'm looking at this bottle now, and then you're telling me that the process by which you pour water into this bottle is a trade secret, I won't believe you. Because by mere looking at this bottle, I'm seeing that there is a hole on top with a cover. So my mind tells me that if I remove this cover, I can actually pour water inside. So that is not a trade secret. But if this thing is like a beverage now, and then I test it, and I can't fathom the ingredients you use and how you mix it to come about it, that is a trade secret. So it's not something that is readily ascertainable by others by mere looking at it or observing it or trying to reverse engineer or whatever means. So these are the things you have to show, that to prove that that information is a trade secret. Like I mentioned, there is no law, expressly saying, oh, the way you have trademarks and all that for trade secrets, you go and register it, this one and that one. But if you have all these things, of course, um how do we say it in Latin, that where there is a right, there is a remedy. Of course, if you have all these things and then somebody, probably an ex-employee or something, reaches the trade secret by disclosing it to third parties or carrying it to a new workplace, then you can take action and go to court and all of that. So that's it about trade secrets. And plant variety is one of the, not strictly, at the core of the IP, but it's also one of it because under patents, under our patent act, there are some inventions that were excluded from patent eligibility. You see one of which is plant varieties and some kind of microorganisms and all of that, excluded from patent. And then they now found their eligibility under the Plant Variety Act, right? It's not very common yet, but at least it's there. There are some persons that may have eligible rights to it, but they don't even know. Farmers that try to cross-pollinate some what things, or people that cross-pollinate animals and all those kind of things, crossbreed, all those kind of things. Most of those people, they may not know that what they are doing, and they can actually, own a right to it if they do the necessary filings and all of that. What's the last one? Next slide. Let's see what the last one is. Okay, so that's it. So, but there are, I mentioned that if at the end we have a bit of time, we'll take some, maybe I'll just take one or two cases that illustrate some points, and that will essentially be on trademarks. And why I want to draw this point is because in another country it has now happened, so it's very possible to also happen in Nigeria. We talked about IP rights being territorial, right? And then we mentioned there are lots of treaties and conventions and all of that that try to either set minimum standards or try to give you some form of multi-jurisdictional protection. Take Madrid Protocol, for instance. The aim of Madrid Protocol is to be able to allow you to file your trademarks in multiple jurisdictions with just one filing abroad or in any of the this thing. There are processes to that, right? These are just trying to simplify the processes because in effect, what it means is that if you register your trademark ABC in Nigeria and you do not register it in Ghana, your right is only limited to Nigeria and not in Ghana. So you won't be surprised when you go to Ghana tomorrow and you see that somebody is using that same exact trademark for the same thing you're using it in Nigeria for another thing. So what it means is that you will keep on registering in different countries. What we usually tell our clients is when you register in Nigeria, if you know the other countries that you know you are going to expand into very soon for business, register in those countries as well. I know one time I've had registration for, it was actually myself and in one of when we worked together for a particular banking institution in more than 50 countries at once. You understand? But if you're in a jurisdiction that allows for Madrid Protocol, you can actually just do one filing, designate all the countries that you need, and they will all be registered in those places. You pay the fees and all of that. But if you're in a country like Nigeria that we are not party to Madrid Protocol, we have not domesticated, you have to keep doing individual registration in multiple places. But then it now comes down to there is this argument that will always come up in oppositions and all, which is the argument of well-known trademarks. There are some persons or some brands or that have considered that their trademarks are so popular that even if they don't register it, they will still be entitled to protection. Yeah. Under our Act, Section 3, it says even if you do not register your trademark and somebody is you're not infringing, somebody is using it, you can sue for passing off. So your right to passing off, common law right to passing off is reserved. We agree. But even proving passing off is not as easy as proving it. Because for infringement, all you have to do is to show your certificate of registration and that person is using a similar mark and all of that. But when it comes to passing off, you have a whole lot to prove. But that aside, for well-known marks, you will see argument or hear arguments of, okay, this brand is an international brand, it's in the US, they are not registered in Nigeria, but because we're an internet age, everybody knows about it, people hear it, people see it on YouTube, people do this, do that. And then tomorrow somebody wants to register or somebody has registered a similar thing in Nigeria and there is an opposition or a court case. You now hear arguments like, oh, this US mark is a well-known trademark. It has to be protected by all means, whether registered or not. And the Nigerian person will be arguing, no, our law says first to file. I was the first to file and register here, so you can't take it away from me, you can't stop me. Even on the other angle, in Africa, for instance, we have regional bodies that register trademarks. We have OAPI, the French, the countries under the French as region or whatever. We have ARIPO, the ones in English, but Nigeria and probably South Africa, they don't belong to any. You also see people like if they register in OAPI or in ARIPO, they take it that they've registered in all the countries in that list, without even making sure that all those countries they domesticate their laws or not. So a recent decision in Tanzania, for instance, says that you registered in ARIPO. ARIPO is a part of Tanzania is a part of ARIPO, for instance. ARIPO is just like saying ECOWAS. So let me bring it down for those that have not practiced in IP. So you just say, oh, because you registered it in ARIPO, that you've now registered in all the countries in ARIPO. The Supreme Court of Tanzania said no, that Tanzania has not domesticated that treaty. Therefore, if you register in ARIPO, even though Tanzania is a member, you will still come back to register in Tanzania. If not, no protection for you. Now, bringing it back to Nigeria, because we've had lots of cases like that in Nigeria. We've had cases, there is this very popular one, the Procter and Gamble case, where TRIPS agreement, we mentioned TRIPS agreement in the second slide. You know, one of the parties tried to say, by the provisions of TRIPS agreement, we should recognize and protect well-known trademarks. And the other party say, no, if it is not duly filed, registered, then we can't talk about it. A very important dictum came from that case. The Court of Appeal, particularly Justice Ogunwujimi, then when she was in the Court of Appeal, said, even though we've not domesticated TRIPS agreement, but then that we have to join the Committee of Nations in interpreting trademarks law in a liberal way to protect well-known trademarks. Very sound, because you know why? I actually support that dictum a lot. It will discourage people copying foreign trademarks. It will discourage deceit, because people do that a lot. It will discourage deceit. You copy trademarks and you want to deceive people and all of that. But on the flip side, it also discourages revenue that is coming to the trademarks registry. But if you say that we can protect trademarks without registration, it will cause some kind of confusion, in the sense that it will discourage revenue. And then remember we talked about prior search. Then that means that the list of marks you would conduct prior search would not be exhaustive, because if you are now going to conduct search on registered marks and on foreign marks, that would be very confusing. In other cases, there are these two farm mill cases from Federal High Court Abuja, and the court, similar argument came up, the same TRIPS agreement, and the court said in that one that this TRIPS agreement that you're trying to cite has not been domesticated. And from the principles of law, section 12 constitution, this and that, they are not applicable. Therefore, if you do not register, you can't claim protection.
Yes.
You understand? So the end point of the whole game is, if you are dealing with a client that has any IP rights, registration is very important. The good thing I always say, to, at least from my experience, even though some persons consider our fees very costly, but from my experience, registration fees in Nigeria is actually
Very
not
cheap.
very cheap. To file a trademark is official fees about 16,800. Any other thing, the other fees are just attorney fees and all of that. Similar with patent, not even up to 30,000. So as much as possible, register in all the classes that are necessary. Do all your registration. There are some IP rights that can be eligible for trademark registration, copyright registration, and register all of them. Have all the certificates, because you don't know the one that will save you when a dispute arises tomorrow. So we'll stop it, and I'll hand mic back to Nta.
Christian, thank you so much. Before I take the questions, we won't be able to take all the questions, because right now we have just 10 minutes. What I'm going to say at this point is, sitting through this presentation, Christian, it actually reminds me of why, we are in this practice, why IP practice is interesting. We've worked together for so long, and when we were in a very big law firm, people had always wondered, what do IP lawyers really do? The only time we used to shine was when our invoices, when everybody sees what we have built. So the whole presentation, actually, it's just a tiny we've gone through this presentation in less than 2 hours. But trust me, and I'm sure for those who know a bit of IP, know that this is what a few of us, who use this as a specialty, do every single day. It is what we do every single day, because it is a lot. So, like I said, we're not going to be able to take all of these questions. For somebody who asked how to become a trademark or a patent agent, it is done online. Familiarize yourself with the IPO website. And if you have colleagues or friends who are in this practice, ask questions. There are people who this is all they do every day. They are IP law firms. If you do not know, do your research before telling a client. Every day, people tout themselves to be they can register your trademark, they can register. Meanwhile, they really don't know how to go about it. So I would say that before you take on a client's work, please always ask questions first, so that you do not because for Christian and I, we belong to international organizations, we belong to international networks, and we travel. Anytime we go, we travel on this, there's always a complaint. We gave this one work, the person didn't know what to do. So because we want to be great ambassadors for for the Nigerian legal sector, please, it is advisable that you find out, from your colleagues who are knowledgeable in any practice area before you take on that work. We have just 8 minutes. Like I said, we won't be able to take all the questions. Christian, there was an interesting question which you have just answered, which is that, does it mean that one can register a design as a trademark and industrial design at the same time? Yes, that can be done. Then another question was, since the examination under patent in our laws is only as to form, there are no situations where certificates are issued to acclaimed inventions which are already part of the state of the art. Christian, do you want to throw more light to
So
that,
that's right.
or
So I
we have
try as
just
much as possible not to expose some, like, call it down, errors or misdemeanor that you can see at the. So because our processes are largely manual, so just give room for human mistakes. They don't have a database where everything can easily, they have a database that they check things, but you can't say it is very comprehensive that you can see everything. And remember, even if the title may be misleading, you can have a title that say an invention that flies you from Nigeria to US. When another title, which may be the same claim, will now have a different title, will now say an invention for teleporting. Another one will say an invention for moving. So if you're looking at only titles, you may say, oh, may think that they are different. But it's when you look at the claims, you understand? So if it is likely for you to see somebody being granted a certificate for something that has already been registered by another person, that's why, let me shock you. Under our Patent Act, even the act itself says a patent is granted at the risk of the patentee. What does that mean? That I'm giving you a certificate does not mean I am guaranteeing you the validity. That is simply the meaning. So what it means that I have given you a certificate because I've not done substantive investigation. I've just done what's it called, examination as to form. Take this certificate in the name of the president and go. If tomorrow Mr. B attacks you, you should go and settle it in court. That's just the implication.
I like that somebody's laughing. How does copyright law protect an artist who submits a demo to a label, which goes ahead to release the work through another established artist?
So I didn't get that.
It says, how does the copyright law protect an artist who has submitted a demo? So take, for instance, he created the work, he submitted a demo to a label, who then takes that work and releases it, and gives to another artist to, you understand? So take, for
Yeah,
instance,
to
an
perform
unknown
on top. Okay.
artist. Yeah,
So it's
exactly.
simple. That's why, when we talked about copyright, we talked about dates. In the absence of registration, we have to prove. I will give you an instance. What people do in those days. Probably you typed a novel, a manuscript, and you want to, sorry, discuss it with somebody, or you want to send it to a publisher, something. You know how they do it? You first of all send that manuscript to yourself via email to have a timestamp, to have a proof that as at 1st of January 2019, I'm the owner of this, I developed this. If you are going to give, let's say, an artist or whatever your work, maybe even to preview, and then the person now goes ahead to perform it. If you send it via email, say, dear so, please find out the lyrics that we are supposed to use for I have this song, and then tomorrow you're hearing the lyrics somewhere else. That email that you sent with that attachment and it is a proof to you, like when you sue the person, it's a proof standing in your that you are the one that developed this and sent it to this person. There are just have to prove. If you're able to register it, the copyright registration, so that I have a certificate, because if you're registering copyright, you will actually upload, here. So if you're able to do it, fine, you have a certificate. If not, there are other ways to show it that you sent it via email, this and that. Because I know I've heard things like that in the past. Somebody saying that I wrote that lyrics and then another person went to perform it. And I keep saying, why not just sue the person and go and prove that you did? Why would you? If you actually have no proof, then I don't think the court will help. But if there is proof, you're able to, you know, prove your point.
So can a theme of a concert or show be protected under copyrights? I'm sure this person is talking
So
about
topics
this.
cannot so okay,
Yeah.
maybe I didn't mention that. So copyrights do not protect let's say topics or titles. Those ones. So for instance, if you have a book now, a novel, the entire book is copyright, but if there is a title, you just do trademark. A movie, do trademark for the title, because those short titles, short forms, they are not eligible for literary work. They are not long enough to be considered literary works that are eligible for copyright protection. So that's why we said you can have a work that will be eligible for so many different IP right protection. So meet an expert and identify the various aspects that will be eligible for protection in the various types of IP.
Okay, so this will be the last question that I'm going to be able to take. Please, what's the difference between piracy and copyright violation?
I think it's just the way the person has said it. Piracy is a violation. Piracy can come in different forms. It's either you are photocopying somebody's stuff, or you're in the way they say it in the olden days, you're dubbing the cassette or the movie or whatever, or you are providing an illegal streaming site. For those of us that, not also because I don't do it, for those of the people that go on Telegram channels and all those places to download movies that that have been exclusively left for Netflix. Instead of paying 5,000 something subscription monthly to Netflix, you go on Telegram channel and go and download the movie and have it in your phone. Or instead of going on Spotify to subscribe, you go on not just how do you call that? Not just musicok.com. I've been waiting to download those songs from your browser and have it on your phone. So all those are forms of piracy. They are different forms. They are all violations of copyright, the exclusive right of copyright of the owner.
Okay, so it is now time. I want to thank everyone for being a part of this presentation, this training today. Tomorrow we're going to have another presentation which will be taken by Mrs. Chinasa Wana. Thank you, Christian, and I'm going to hand over now to Mr. Rojikwe to conclude the session.
Yeah, thank you very much, Nta. Thank you for the presentation. Christian, brilliant presentation. Thank you very much. We're extremely grateful to you. We've had a lot of people logged in today. On Zoom alone, we had more than 1,000 people logged in today. And on YouTube, about the same number. So, and I can see that people stayed on throughout. You can also see from the comments that people appear to have learned a lot from the session. and I learned a lot myself. So Christian, well done, Nta, well done. Thank you very much. And I must say to everybody that we owe a huge debt of gratitude to both of them for sharing their knowledge with us, even on how to make the money. So thank you. We're so grateful. And I must acknowledge the fact that they have done this at absolutely no cost to us or to yourselves. And it's what we want to see in this profession, where people actually willingly give back for the improvement and development of colleagues. So thank you, everybody who's logged in also. And we're also grateful to the MBA ICLE. Sarah Omega was here a while ago, and I still think that they're here monitoring. I would ask that, I just want to let you know that today's session, as well as previous sessions, are all on our YouTube channel. And I'll ask as many people as possible to subscribe to the channel so that if you want to get a review, you can get that. We plan to circulate the slides to everybody who participated at the end of the entire session. And then there are a lot of other questions that people are asking. I've asked that a screenshot be taken of the questions so that the ones that we couldn't handle today, we'll handle tomorrow or next or the day after. So thank you, everybody, especially Nta and Kristen. And thank you for all the participants. And I look forward to seeing you all tomorrow. God bless you all. Bye-bye.
Bye.
Well done, Chris. I can see that some people are asking for CPD links. All those that logged in on Zoom will get their CPD points automatically. I understand now that those who logged in on YouTube will not be able to get their CPD points because links are no longer being distributed on that line. But importantly, I just want to say that our focus is on making sure that people get the training and development that they need more than any other thing. Thank you very much.